Does not break the parent-child relationship, but it allows the child to stay in the United States with the guardian or conservator. My name is John Lowett. Today we're going to discuss a very generous part of the immigration and nationality laws of the United States. It involves the protection of certain children who are already in the United States and allows them to proceed forward and apply for a green card. This particular provision of law is called Special Immigrant Juvenile petitions. Special Immigrant Juvenile petitions are applications made by guardians or conservators on behalf of the children who are in the United States. In order to qualify for a special immigrant juvenile status, the first thing that has to happen is an action must be brought in the state court where the child is residing. It does not matter whether the child entered with a visa or just came across the border, or in some cases they even entered with visas. The key in the state court part of this part of the law is that the court makes certain findings regarding the juvenile. One of the findings is that it's not in the best interest of the juvenile to return to their home country. In order to make that finding, the judge has to hear evidence of abuse, neglect, or abandonment of the child. The hearing, when it's concluded, results in an order either appointing a guardian or a conservator for the child. This does not break the parent-child relationship, but it allows the child to stay in the United States with the guardian or conservator and apply for a green card. The child, who is the beneficiary of the petition in the state court, can immediately file for a green card as soon as the judge signs the order. This particular section of law is very, very useful for children who are abandoned here by their parents, or children who came to the United States and the parents could not afford to take care of them, and or the parents came to the United States with the child and they had to leave and go back home, but for a variety of different reasons could not take the child with them. For example, if the family was from a country where there was a war going on, or there was a medical epidemic, or there was violence that could not be controlled, this is a way the child can seek the protection of the laws of the United States and eventually become a permanent resident and live and work here for the rest of the child's life. The child could also then go on and become a citizen. And so for many, many children, this is a benefit that protects them from what might otherwise be a very disastrous childhood in their own country. And since it doesn't require any legal entry, many children who have been here for several years or just a few days are able to avail themselves of this section of law. And it helps actually keep families together because although the parents may have to leave, the child can be reunited with the parents once they get permanent residency. And then if the conditions continue to exist where the child's health or safety is threatened, the child can come back to the United States. Most states require that such an order be granted before the child turns 18 years old. Under USCIS law, the application for special immigrant juvenile status must be filed before the child's 21st birthday. If the child turns 21 while the petition is pending, they can still be granted special immigrant juvenile status. The guardian or conservator, in most cases, is a relative who's already living in the United States in legal status. However, it does not have to be a relative. It could be any person who knows the child and knows the parents, because the parents must give consent to the guardianship to take place. And when they give consent, they also give consent as to who the guardian will be. The parents still have the right to revoke the guardianship at any time because it is not like an adoption where the relationship between the parent and the child is severed. In this case, the parents remain the parents through the whole process, although the child lives in the United States with the guardian. In many cases, the parents, if they're in the United States, will testify at the guardianship hearing in the state court about the reasons that they feel the child has been abused, neglected, or abandoned, and why it's so important for the guardian to be appointed. This kind of application like I said, can be filed in all 50 states. And the key is to have the guardianship or the conservatorship order issued as soon as possible, once the decision is made that the child's best interest would be served in staying in the United States. The child will be able to go to school. If the child's old enough, the child will get a work permit. And during the process, before they become a permanent resident, even travel documents can be issued to the child. So if there are children in the United States who need this kind of protection, this is a very generous part of the law, and we do these applications on a regular basis in my office.